a production of the New Jersey courts.
This begins an interview with Justice Virginia Long on January 15th, 2019 in Lawrenceville, New Jersey with Sean Illingworth of the Rutgers Oral History Archive for the New Jersey Supreme Court Oral History Program. And Justice Long, thank you so much for having me here again.
Well, thank you for doing this. I think it's a wonderful, wonderful venture, and hopefully people who come after us will benefit from it.
All right, thank you. To begin, I wanted to talk a little bit about some of the cases you might recall.
Right.
And one of the most prominent you were involved in was the Lewis v. Harris case.
Right.
Could you tell me a little bit about what goes into
Sure.
a case like that?
Now, Lewis versus Harris is interesting from many, many perspectives, obviously substantively. So there you had lesbian and gay couples who sued to have the marriage laws declared unconstitutional because they treated those couples entirely differentially from heterosexual couples. And the court unanimously agreed that it was unconstitutional for that differential treatment to exist. The case broke down in terms of a majority and a dissent over the question of remedy. So 4 people on the court, led by Justice Albin, said, well, we'll give the legislature 180 days to either adopt new marriage laws or to adopt a civil union statute. The dissenters, of which I was one, felt that the mere existence of differential treatment, that is a different name, civil union versus marriage, even with all of the of equal accoutrements, was essentially unequal. And Chief Justice Poritz wrote our dissent, and basically her point was words matter. Now, what's important about Lewis versus Harris, in addition to the substance, is the fact that it is a classic Supreme Court case. It tells us how difficult Supreme Court cases are because there are 2 or more principled outcomes that the court could reach. It's not the kind of situation where you say, oh, you did something wrong, you did something right, you win, you lose. These are policy judgments that the court has to make, and it makes our case decision-making so much more difficult than it was on the appellate division, for example. Another reason that Supreme Court decisions are difficult is because they are pitting rights of various segments of our population against each other. It's not just, oh, well, you have a right, you don't have a right, we'll move on from here. So, for example, in the children's cases, which is basically the way I look at it, V.C. versus MJB, which is what we talked about before. The biological mother who had the child by artificial insemination with her partner, they then break up, and the biological mother says, I don't want you, not only don't I want you to have custody, I don't even want you to visit the child anymore. So there is an autonomous right of privacy of parents to decide who their children are going to associate with. However, what we were balancing there was not the right of the biological mother versus the third party. We were balancing the right of the child to continue a relationship with somebody who had existed as a psychological parent to the child. And what we adopted as the standard there was avoidance of harm to the child. And that is exactly how we decided cases. Similarly, that is the conflict between 2 very important rights. Moriarty versus Bradt, grandparent visitation. Grandparents whose daughter has died, her husband now says, You may no longer see your grandchildren. I just don't like the way you are. I just don't like you that much anymore. And the grandparents sued. And so we were, again, balancing the right of autonomous privacy of the father to choose whose children would associate with. Again, not against the right of the Moriarties, who are the grandparents, but with respect to the child's interest. We held the child deserved to be connected to his mother through her parents, deserved an extended family, and it was to avoid harm to the child that we acted on behalf of the Moriarties. Same thing in D.C. Siblings wanted to visit their brothers and sisters who were adopted by another family who did not want them anywhere in sight. Now, these siblings had lived with the child who was adopted, and so again, it wasn't balancing off the right of the siblings versus the adopted parents. It was looking at the interest of the child. And that is pretty much the way that we operated throughout. But that shows you why the cases are not just that simple to decide. Another one in that vein is Baures versus Lewis, which is the removal case. That is where a mother wanted to move her child to, I think it was Minnesota, to live near her parents so they could help her raise him, and the father didn't want that to happen. Under the prior jurisprudence, it was very difficult for somebody to move under those circumstances. But, and this is important for another principle, all of the social science research, 100% at that time, that was 15 years ago, said that the happiness of the child is inextricably bound up with the happiness of the custodial parent, in that case, the mother. So that if she's happy, she gets to follow her star, the child is going to be happy. And so we loosened the standard and said the only reason you shouldn't be able to go is if there's going to be harm to the child if you move. Now, why that case is important is because 15 years later, the social science has completely changed. And now, all of the social science, unlike what it was then, says it is most important for a child to have both of his or her parents and have their involvement in her life. And the idea of one parent being able to follow her star is not in the best interests of the child. And so the standard again was changed just last year by the Supreme Court, where they said the ultimate issue is going to be the child's best interests. But what's important about that is that's an example of when we don't abide by stare decisis, when we don't stand with an older decision, it's because things have somehow changed. So,
well, it's interesting. It brings up something you mentioned earlier, that you don't just decide. I may be getting the words wrong, but you don't just decide for this case, but thinking about the cases down the road.
right.
And it must be very difficult in the case of children where you have to think of the specific child's well-being, but then the principles involved.
Yep. But if you always keep the child's welfare as your North Star, which is what the court has always done, it keeps I think it just keeps you in the right direction. That you don't let any other extraneous issues take the place of that. And of course that's the most important thing. The court is parents patriae to children in New Jersey, and to have their interest in the mainstream, that I think is another very important action of the court. But what I was talking about, what got us here is why is Lewis versus Harris paradigmatic? It's because there are more than one principled outcome. What other hard things are there that we do? We do, as I just said, we have very significant interests of parties that are pitted against each other, and we have to make judgments as far as that is concerned. We have to be always alert to cutting-edge issues. I think we talked the last time about the frozen embryos. We wrote several decisions on PTSD when I was on the court, recognizing the various iterations of it which could form the basis of either occupational or accidental disability or workers' compensation. These were, and we had, in the same vein, we decided for the first time that to get an accidental disability pension, you didn't have to have a physical impact, that you could have an emotional impact that caused emotional damage, and that would be recognized. So that we recognized in the workers' comp field, a policeman held his dying partner who had been shot. And that was recognized as an accidental, and it caused him terrible mental problems. It was recognized as an accidental disability. The same thing for accidental, that was workers' comp, I'm sorry. For disability pension, we gave as examples, supposing somebody is held as a hostage or sees a shooting, those kinds of things. And these were all based upon the psychiatric literature as far as post-traumatic stress disorder and how it should be dealt with. So again, these are cutting-edge issues. They're just more difficult than just going back over old ground. Green Party, again, we reaffirmed that the mall is now the town square. It wasn't maybe however many 50 years ago. It is now the town square, and therefore the right of the private owner, and they do have the right to decide how their property is going to be used, had to give way to First Amendment rights for citizens against the war, for example.
I wondered if you could also share with us your thoughts on the various Chief Justices that you served with.
I would love to.
Yes.
I was thinking about them lately, and it's interesting to me how much they are alike and how much they are different. I will tell you this much. They're not like Chief Justice Vanderbilt is alleged to have been. They don't have to be the captain of the team in order to participate. They are the most collegial bunch that you've ever met. And they are the same insofar as they are smart, they are hardworking, they are respectful of the views of others, they're collegial, and they're humble enough to acknowledge the possibility that what they're thinking at any given moment may not be the final word. But they were completely different in the way that they operated. Chief Justice Poritz was a professor, and she was professorial in her role. She was the best editor that you can possibly imagine. She made everybody's opinion better. She used those English skills. She often talked about crafting an opinion. She was a great writer. That's exactly what she did. And she was also a great laugher. That's all I can say. Chief Justice Zazali was an artist at heart. Every conversation, every opinion he wrote was shot through with references to art and music and literature, philosophy, Greek and Roman allusions, religion, and they were used as teaching devices. And he was always looking out for the little guy, and he also had the ability to dissipate any tension in a room by telling the most god-awful jokes and puns. You cannot even imagine how bad they were, but it definitely lightened up the room. Chief Justice Rabner is kind of a little bit of both. He is the most glitteringly intelligent person that you can possibly imagine. But he's also a natural-born leader. He leads by example. People want to follow his direction. He is, as you know, the child of Holocaust survivors, and he is always deeply aware of the injustices in society, and he has done amazing things systemically in the judicial and legal system. each one of them was gifted in his or her own way, and it was just an honor, really, to serve with them. And he was a great laugher, too. And when I say great laugher, all three of them were great laughers. A Russian novelist once said that you can tell a lot about a person by the way he laughs, and I think that's absolutely true about those three. These were not cynical, mean-spirited laughs. They were the kind of laugh that you really want to join in. Generous laughing is the only word I can use to describe it. Great, they were wonderful people, and I felt very fortunate to serve under each one of them.
So after your first 7 years on the court, you obviously had to be reconfirmed. Do you have any memories of that process?
Yeah, I was grilled during that process, which I had mentioned before that the first, my original appointment was sort of a love fest, but this time, Senator Adler had just taken over the Judiciary Committee, and he made clear long before even my application came before him that he felt that the Judiciary Committee hadn't been doing its due diligence and that it hadn't been hard enough on looking at the candidates. So I was the test case there. And he was, I mean, I have to tell you something, there was nothing unfair about the process at all. He even sent me a list of the cases I had decided on the Supreme Court. And that's what made the difference. They had these last 7 years of opinions on the Supreme Court to look at. And he said, I'm concerned about all these opinions. I don't like them for whatever reason. And I went in and I had a 2.5-hour grilling by the various senators, but I mean, I guess I held my own because in the end, it went through, I think, with maybe one dissent, I'm not even sure. So, but it was a new day because after me, everybody was grilled. As they, I think the next person to be read up was Justice Lavecchia, and she had the same thing. So, and it's probably a good thing. You know, that's what the Judiciary Committee is there for.
Well, in addition to the reconfirmation clause in the law, the other thing that comes up often is the mandatory retirement age at 70. Which affected you obviously. What are your thoughts on that?
Well, I think I told you before that I would have died with my boots on, and that's absolutely the case. I think they would have been dragging me out of here when I was 95 years old, which is the way the Supreme Court of the United States operates, and even federal courts. They can stay as long as they want. There's no mandatory retirement. And I understand the counter arguments for it. First, the argument against it is that 70 isn't what it was at the time the Constitution embedded it in its provisions. But I do understand the other side of the argument, which is that it gives an opportunity for new blood, new thinking. So I took my bat and ball and went on into the world of private practice.
Well, I want to ask you to reflect on some of the major changes you've seen over the course of your time on the bench and before. The first would be the role of women and how that's changed. The enrollment of women in law schools has obviously become a majority female,
Right.
I think, and that has shaped the profession. What are your thoughts on how things have changed?
Well, I think that it's a great step in the right direction that women and minorities and members of the LGBT community are all fully embraced within the profession now. As you point out, there are more women in law school than men. Women are being reflected now in boardrooms, in the judiciary, in law firms, in relation to their presence in the profession. Not so much for minorities. They still have a way to go. And I think that the Committee on Women in the Courts has opined and is working now on minority women's issues because they have not made the same strides as non-minority women. But overall, it's a wonderful thing, and for the judiciary, it's a wonderful thing for people to be able to look at a judiciary that reflects them.
What about any other changes to the system that you want to reflect on, like in technology or just the culture of the law?
Well, technology has been astonishing in my estimation. The three Chief Justices have worked to make the judiciary accessible to the public, and they have done an amazing job. This afternoon, I am going to watch the Supreme Court, a Supreme Court argument that I have an interest in at 3 o'clock on the website, which gives everyone access to the Supreme Court in ways that they never had before. I used to, in the old days, before there were these webcasts, if I was trying to help somebody with a Supreme Court argument, I would say you've got to go there and you have to sit in the courtroom and watch them and listen to them and get the sense of how they operate. Now they can sit in their own offices and watch Supreme Court arguments from morning till night and figure out who's who might think in a particular way on their argument. That alone, to me, has been extraordinary. Electronic filing, in my day, people were banging on the door of the courthouse at 5 and 1 second to get in, to get their papers filed so that they wouldn't have lost out on the statute of limitations. Now and there were always constantly messengering this and that. I mean, those kinds of things have made the judiciary just a more friendly place for lawyers and the public. So,
let's see. So, after you retired, you came here to Fox Rothschild. Yep. How did that decision come about?
Well, probably the primary reason is my husband's been a partner here for 30 years. So, I mean, I'm very familiar with it. I knew them. And it's an absolutely wonderful firm with a fabulous reputation. So there was absolutely no reason for me not to come here. And it's turned out great. The people are friendly and smart, and I've just been welcomed here as though I've been here forever. And that's been a very easy transition. The harder transition is not being on the court, very honestly. And if I had my way, I would be back on the court. But I've doing other kinds of things, preparing people for oral arguments, helping them do their petitions for certification. I do arbitrations and mediations. So I basically keep legally busy.
Now, you've also continued to do some work on committees.
Oh, yes.
Do you want to share any
Sure.
memories of that?
Well, right now, I'm co-chairing the Committee on Conviction Review. Those are looking back at convictions and seeing whether they were legitimately garnered. I recently chaired the Committee on Judges' Use of Social Media. I'm on the board of editors of the New Jersey Law Journal. I'm on the New Jersey Law Revision Commission. I'm on the board of Legal Services. I have served on the board of Centurion Ministries, which is an actual innocence organization, and Deborah Hospital. And generally, I manage to keep fairly busy with a public schedule.
Just to pick one thing out, what is the mission of the Social Media Committee, and what issues do you tackle there?
The mission is to and it's been done now, to set forth a template for judges to follow in terms of their use of social media. And one of the reasons why this came up is I'm also the chair of the Advisory Committee on Judicial Conduct, which deals with ethical issues by judges. we were seeing a lot of difficulties emerging out of judges' use of social media. They're Facebooking, and issues were coming up about recusals based upon Facebook relationships. And so it kind of was emerging. The problem of judges' use of social media was emerging in that context, in the ethical context, and that as a result of that, the Supreme Court commissioned us to take a look and see what we could come up with. And we did. And ultimately, our determination was you have to abide by the same rules that govern your interactions with people that are not on social media. And when you drill down on those rules, they really give the judges pretty much all the information that they need.
Wow. So any other memories of your time on the bench that you want to share that come out as you look back?
I don't know if it's a memory so much as basically how I feel. I feel that the time that I spent on the Supreme Court was really the greatest honor that I've ever been accorded. I was able, and all the justices there were able to live in the world of the mind, which is a gift to begin with. We had wonderful relationships among ourselves. We held the lives and fortunes of our fellow citizens in our hands. We had the opportunity to do good every single day. We could help protect the poor, the disaffected, children, the disabled, and even the most despised of our citizens. We were able to stand guard over them. And I can only say that it was an honor to have that life, and it is a life. You know what? It wasn't a job. It was, I always say it was more of a calling than a job, because if you were to calculate what I earned and what the justices earn in terms of the number of hours that they worked, we earned about $1 an hour. But it was the capacity to do good things every single day that just made the job extraordinary.
All right. Well, is there anything else you'd like to discuss? I think we may have covered what I wanted to cover. Anything you'd like to add?
No, I don't think so. I mean,
Okay.
I talked last time about, my inspiration, my parents who were my inspiration.
Oh, yes, yeah, your greatest influences.
And they were, because they believed in public service. They believed in the power of the government to help people who needed help. They believed that we're all in this together. And I believe that as well. I think I told you, they never once in all their lives, my mother lived to be 95, never once complained about paying their income tax because they saw that as part of the social compact. And you know what? They believed in me. And so...
You mentioned before humility was also a big part of the culture.
Yep. Oh, my gosh. I think we talked about this. You just, in my home, in my school, you didn't talk about yourself. You didn't brag. You didn't say things were going too well because the powers in the universe might look down at you and give you the evil eye. But all of those things, that kind of helps you to recognize when you become a judge, for example, that it is a cross and not a crown. It is a duty, a series of duties and obligations that you take on. It doesn't make you the king or queen of the universe. And I think that background really was helpful.
So obviously you've had a stellar career, but your family has also grown by leaps and bounds, let's say, over the course of the same time. Can you tell us a little bit about that?
Well, my husband and I have been together for 45 years, kind of a partnership of equals. We both kind of try and do our share. We have 3 children and 7 grandchildren and 1 great-grandchild, and they all live in New Jersey, so we see them regularly. My oldest daughter is an assistant prosecutor. My youngest daughter is an assistant prosecutor, and my other 2 are teachers. And we spend a lot of time together. We took an Alaskan cruise as a family last year, which was really fun with the little ones. And I mean, they are the kind of most important thing in our lives. We are movie buffs for ourselves when we're alone. I love cooking, and we do a lot of cooking together. But our focus basically is the kids, and we are just joyful to have them. We had them all for Sunday dinner, and it was just a wonderful day.
Well, it's interesting. One of your children went into the family profession.
Right.
Was there any, when each of your children was coming up deciding what they want to do in their educations or careers, was there any trying to push them one way or the other, or just let them decide?
No, we never tried to push them, but it was obvious that there was like a genetic strand in here. John is a lawyer, I'm a lawyer. John's sister and brother-in-law are lawyers. Our cousins and nieces and nephews are lawyers. So, I mean, we'd come from a family of lawyers, but to me, the interesting part is the one who became a lawyer, swore her whole life she would never become a lawyer. So, but I guess genes will out in the end, right?
All right. Well, thank you very much. I appreciate all your time.
You're welcome, I'm sure.
Thank you.